Welcome back to Good Law, Bad Law. My guest on today's episode is Ariela Gross. She is a historian and professor of law at the University of Southern California and the co-author of a new book called Becoming Free, Becoming Black. What she looks at is the experiences of not only enslaved people of color, but free people of color, and how the law in Cuba, which of course comes from a Spanish law tradition, in Virginia, which comes from an English law tradition, and Louisiana, which comes from a whole hodgepodge of English, French, Spanish, and who knows what else, a little voodoo thrown in maybe. How the experiences of the law taking shape in those parts of our world shaped not only the experiences of those seeking freedom, but shaped the laws that we have seen throughout the period since the Civil War, through Reconstruction and Jim Crow, and even up to today. When the president talks, for instance, about immigrants and sending them back, that harkens back to a time when the law in our country was all about sending back even free people of color in this country. So what an incredible book this is. I'm so enjoying it and recommending it, but even better for you, what a great conversation Ariela Gross and I have on today's episode of Good Law, Bad Law. Stay tuned. You know, it is no secret that the issue of race continues to be something that we wrestle with as a people in our country, in our society, even in our politics. It's already been a big issue in the election this year, and I imagine it will continue to be so. One of the things about race, though, that I didn't realize until I started reading the new book by my guest today is the extent to which the history of race in this country is as much about the law of freedom as it is the law of slavery. And all the laws during the founding of our country and the early years of our country during the colonial period and up through the first 200 some years of our country's history. And to talk about that and how that matters, not only as a matter of historical interest, but how we can better understand issues of race today if we understand the history of the law of freedom in our country. I want to welcome my guest, Ariela Gross. She is a law professor. She's actually the Sharp Professor of Law and History and co-director of the Center for Law, History, and Culture at the University of Southern California, the Gould School of Law. Ariela Gross, thank you so much for being on Good Law, Bad Law today.
It's my pleasure. Thanks for having me.
I'm really enjoying your new book. You're the co-author of this book called Becoming Free, Becoming Black, Race, Freedom, and Law in Cuba, Virginia, and Louisiana. And of course, as I teased in the intro, I want to ask you about how the laws of freedom were used in the early part of our country's history to advance the interests of enslaved people and formerly enslaved people. And of course, how these three formerly slave parts of the world, so closely related, Cuba, Virginia, and Louisiana, helped shape that history, and how that, of course, bears on so much of what we still are thinking about and wrestling with today. So maybe you could start, Ariela. Tell us a little bit about yourself and your own background, and how you and your co-author, Alejandro de la Fuente, came to write this book.
Absolutely. So I am a legal historian. As you said, I teach in a law school, but I've always written about issues of race and the history of racism in the law in the United States. And my last book had been a study of the United States, which traditionally has always been contrasted to Latin America in terms of race by the idea that, oh, in Latin America, race is fluid and there are many gradations of racial identity, and it's much looser, but in the United States, everything is black and white. And my work was really all about showing how big the middle grounds were in the United States. Deep in our history, it's never been just black and white, and that the people who were in the middle, who had their identities contested in the law, not only were there quite a lot of them, but those contests, I think, were quite important to the development of race in the law. And so I got interested in thinking comparatively, returning to that question, well, what is the difference between the U.S. and Latin America? And working with my co-author, Alejandro de la Fuente, who is a Cuban historian, we started thinking about that topic. And what we realized, the more work we did on this, is that it's not that, the systems of slavery in all of these places were equally harsh and difficult, and the laws regulating enslaved people actually look quite similar across all three places. But what was really different was the law, what we end up calling the law of freedom, but it's a little misleading because there's no one law of freedom. Yeah. It's about how possible is it for someone to become free, to claim and achieve freedom in a slave society, and how are their lives regulated to draw that line between black and white. It's really about drawing that line of race. It's really more about free people of color, and that ended up being the story that we told, and the answer to why by the end of slavery, by 1860 in the United States, and a little later in Cuba, why the possibilities of citizenship look so different for a black person here, or in either Louisiana or Virginia than in Cuba, and that we argue is because in the United States, citizenship becomes tied to whiteness, and that doesn't happen the same way in Cuba.
Interesting. Well, and maybe that's starting to answer the question that I was just about to ask you, which is that you said something about how in the experience in the United States compared to the slave history in a place like Cuba is different because here in this country it was more black and white, and I know there are many meanings behind the idea of things being black and white. What do you mean by that, and how do you see those differences?
Right. So I actually think it's not that it was just black and white here. In fact, one of the things that I think is most interesting in the United States is that in both Virginia and Louisiana, there's still a significant indigenous presence in colonial America, and that wasn't true in Cuba by the time Africans came to the New World. And so here, or I should say in Virginia in particular, race and blackness is really defined legally in contrast to Indian identity. And one of the things that happens during the Age of Revolution is across all of these three places, it becomes more possible for people to claim their freedom, to sue for freedom, people who are enslaved. But in Virginia, in particular, one of the main ways to do that is to say, actually, I'm Indian. I'm descended from an Indian grandmother, and she was wrongfully enslaved. And so it ties the freedom claim to a racial identity of not being Black. And that doesn't happen in Cuba, for example.
And there were people who actually were quite successful in making that argument. And I want to get into at least a story or two about that. But in terms of the way you approach this book, this I find very fascinating. I think most people can understand the idea of a comparative study, and just from the title alone, we know that you are looking at the experiences in these three different places and comparing and seeing what is similar and seeing what is different about the experiences there. But I also found it fascinating how you went about your research for the book in looking to court records and testimony in court records. Talk a little bit about that, because in this digital age, of course, if you want to go onto the docket of a court and find some case, it's pretty easy. But to go back to the 18th and 19th century and look through court records to find these stories, I mean, that must have been quite a challenge and quite a different experience from what we're used to today.
Yes, unfortunately, we don't have quite the same access to the older cases that we do today, although it's remarkable how many archival collections are starting to be digitized. But I would just go back to that question of what we get from these old court records. I don't know how many people are even aware. Often people say to me, I'm so surprised to learn that a slave could bring a lawsuit.
Right.
That's amazing, right?
Right. It is.
It's remarkable that we are able to recapture the voices of people who were often illiterate, had no resources, they're held in bondage, and they get lawyers and bring their claims to court. And often what we find in the records in court is the incredible way that even before they've gotten to the courtroom, that they've taken charge of aspects of their lives through, for example, self-purchase arrangements where they've, made a deal with an owner to work overtime, late at night on Sunday to earn wages and put that money towards buying themselves and their family members. And maybe it gets to court because the owner, reneges on the deal or something like that. But we kind of get at this window into a world of people using very little resources to do amazing things. And those claims of Indian identity are interesting because if one person wins a lawsuit based on, an Indian ancestor, an Indian great-grandmother, potentially there are dozens, maybe even hundreds of people out there descended from that same woman. And the news travels through their network, that if you could trace your ancestry to, there was this one woman, who was known as Butterwood Nan in early Revolutionary Virginia. And literally, there are a dozen lawsuits brought in far-flung counties in Virginia claiming a tie to this woman because people learn I could bring a suit. I'm a second cousin of somebody who won a lawsuit. So that is quite amazing.
And let's pause on that just for a moment because, and I promise we'll relate this to today. We're recording this episode actually the day after Super Tuesday, and I watched some of what Joe Biden had to say last night. He had quite a good day on Super Tuesday yesterday, And he echoed something that many people have been saying for a long time. I'm thinking powerfully of the words of Martin Luther King Jr., who made the same kind of observation that although slavery was, and there's no other way to undo, there's no way to undo this, and there's no way to undo or sugarcoat just how deep a stain slavery has been in our country. But the idea of America and the idea of freedom in this country, even though it was so imperfectly executed for so long, the idea is a great idea. And here we're talking about people who you would imagine are the least likely to get access to the legal system and actually have courts, have judges affirm their legal rights in court. It really is, it's remarkable. And I mean, there's the one story you tell about a woman who had made a contract with her slave owner to buy her freedom, but didn't have the funds to fully pay the amount they had agreed to. And not only were they able to put this into a contract that a court would find enforceable, which in itself is pretty amazing, but the terms of the contract allowed that if she were subsequently sold with the full balance not yet having been paid, the sale would be subject to that contract, meaning someone who would purchase her, which I mean is such an evil idea, but the idea that future slave owner would be bound by the terms of that contract. I mean, that is a remarkable story.
That is a case. It's one of our. It's kind of one of our earliest cases. It's from Havana in 1690, and it actually illustrates one of the key differences between the places we're looking at. But I agree, it's completely fascinating what happens in Cuba. That practice of kind of buying yourself on installments was called coartación, and it's a uniquely Spanish legal practice, not because it doesn't happen in the United States. It does, but it's not backed up by law in the same way. People make those contracts, but they're not enforceable if it comes down to it in court. There's no right of the slave to have their contract enforced. So it happens in Cuba. What's really interesting is that in Cuba, it starts out just as the bare right to have the price fixed, and the owner has to accept the rest of the price if you come up with it. Mm-hmm. What enslaved people add on by just pushing on that, they take what's initially just this right to have your price fixed, and they push it to what you mentioned, the idea that you can take that price and bring it to somebody else. That was known as carrying paper. You could go to another buyer, find someone else to buy you and say, you know, can you come up with the $300? And then the owner has to accept it. And even more remarkably, they added in, they pushed for the right. If I've paid $500 of my $800 price, to own 5/8 of myself, which is a kind of remarkable claim. Like that fractional ownership, I own 5/8 of my labor, and so every 3 days of the week I should be paid for my labor and put that towards my price. And that's what Juana got written into her contract. And that was a real advance. Eventually it gets codified into the law in the 19th century. Louisiana becomes Spanish for about 40 years in the late 18th century. And as soon as the Spanish arrive in colonial Louisiana, people start making claims for coartation. Like they get the news, they start doing it, and it lasts into the 19th century. Even after Louisiana becomes American, you still find cases of enslaved people trying to enforce those contracts in court. And even making the argument, I found a case as late as 1843 where a guy named Francois tries to say, I own 5/8 of myself, and the Supreme Court judge in Louisiana, American Louisiana, is like, oh, I laud you on your imaginative argument, but no way.
All right. Well, maybe I got too excited too quickly then, because maybe people weren't finding the same kind of success here that they were finding in Cuba, and I guess that how does the fact that Cuba, coming from a Spanish law base, whereas say Virginia comes from an English law base, and Louisiana comes from anybody who's been to Louisiana knows. I mean, it comes from a hodgepodge, not only of cultures, but of legal systems, Spanish, American, British, French. How do those origins in law shape how successful enslaved people were able to be in getting access to the courts, in getting access to even very, very limited rights? I mean, we're talking about someone owning only 3/8 of themselves or 5/8 of themselves. I mean, that's hardly what we would want. But for the time, how do those origins in law shape the different experiences? I mean, that's obviously a big question and a big part of your book, I know. But
so it's interesting. I mean, there's a lot of change over time, but starting at the beginning, I'd say two things. One is the Spanish tradition. So the Spanish colonists have a lot of experience enslaving Africans in the Mediterranean before they arrive in the New World. And so ironically, in the beginnings of the colonies, it's the Spanish who show up knowing what to do and getting right down to the business of establishing slavery and racial distinctions in law, because they're already pros. They've been doing it in in the capitals of Spain already. Whereas the English show up in Virginia and they don't have a legal precedent, and they don't settle all of the questions about slavery from the start. Like, there are still people who are able to claim freedom based on a white father because they haven't yet settled that your status passes through the mother. There's still people able to claim I'm Christian and I should be free, which is a no-go in, most slave systems in the New World, because they convert all the slaves but don't free them. So 17th century Virginia looks like, oh, this could go in a positive way. The big difference is in Cuba and throughout the Spanish Empire, they never restrict the right to become free. They never restrict a master's right to free a slave. Whereas in both French Louisiana and in British Virginia, the reaction to slave rebellions and making alliances with Indians and English servants is to crack down on the possibility of freeing slaves. And again, there's this moment of opening at the Age of Revolution. Northern states free slaves, and it looks like southern states are loosening things. But it's met with this crackdown and reaction. And we argue that it's actually, ironically, the political system in the U.S. Republic, the opening up of democracy and equality for people who are free, for white men who are free,
Mm-hmm.
that
Because
leads
initially it's only
to
white men. Yeah.
right. But that is what leads them to say, "Oh my gosh, we can't, we can't." If we're going to extend the vote to everybody, which is what they're doing in 19th century Virginia and Louisiana, they're taking away property qualifications.
Mm-hmm.
They're putting in all these revolutionary principles into practice. They're like, we can't extend that to black people.
Mm-hmm.
We better get rid of them. And so there are these movements to remove free people of color from the state, from the United States, to send them to Liberia.
But why couldn't they? Because that would be it was perceived that would be a threat to white people's rights if blacks had citizenship rights.
Yes, it is this. It's the connections between the racism, which is there in all of these societies, just as much in Cuba. This belief and you see it in the scientific discourse of the time. They're
Mm-hmm.
comparing the skulls and worrying about believing in biological inferiority. You see it in the religious and in the legal. All of these, the rise of this kind of biological racism, but in a monarchy and an empire like the Spanish Empire, it's like, well, it's okay if there are people of inferior status, because everybody's got a status in this hierarchy, and
Mm-hmm.
they could still be rights-bearing subjects of the king, but they're just in this low status. But in a
Mm.
republic where everybody who's free is potentially on the same level, it looks very scary too. And also because they're so afraid that free people of color are fomenting rebellion among the slaves.
Yeah. Well, and
And they have
the
reason to
other
believe that too.
yeah, right. And more as time marched on. And the other development that you point to as being significant in the American experience is something you already alluded to, which is the distinctions that grow up between North and South. And of course,
Exactly.
um, anywhere you had slavery, in any of these colonial societies, slave labor was crucial to the colonial economy. Um, but in the South, it was absolutely indispensable to the Southern economy. So how since slavery was so crucial to any slaveholding uh, economy, how does the distinctions that become more and more stark as the decades go by between North and South in the United States, how does that how do we get a different how does that become a factor in the
Right.
differing experience in this country?
Yeah, so I think you hit on it exactly right. It's what's really threatening to um, slaveholder, what slaveholders, Southern slaveholders perceive as really threatening to them, is the rise of anti-slavery in the North, and it's a combination of the true abolitionists, the who are always kind of the left fringe of politics, the people who are saying, no, you must end slavery right away. People like William Lloyd Garrison and Frederick Douglass.
Mm-hmm.
That's really scary to them. But also the growing kind of northern uh, anti-slavery that's not about any love for black people, but it's just about the political competition between like which of these sections is going to take over the territories and become politically dominant.
Mm-hmm.
And so part of the response in the South to abolitionism is this ideology of this vigorous defense of slavery as a positive good, right? This idea that black people are happiest, and it's not just like about racial inferiority. It's this idea that they're actually best off and happiest under slavery. It's not a necessary evil. It's actually a really good thing to have slavery. And And that goes together with what I talk about as white men's democracy, this idea that you can also appeal to non-slaveholding whites who are actually a majority in the South and get them to buy into the system by saying, yeah, you might not be as rich as we are, but hey, you're white and you have all of these rights that go with being white, and so you should also support us against the North. So it's really the politics that rally around this kind of white supremacist, argument for slavery, and free people of color just do not fit in that model. Like it makes no sense to have a black person who is free once you've set it up that way.
Well, and it's interesting too because, of course, you have North and South, and you have courts in both northern states and southern states. But ultimately, just even today, I mean, we have higher courts in this country that resolve disputes between states. But somehow, before the Civil War, I mean, is that happening? Are any of the cases that you looked at which may have seen a different result if they were brought in Mississippi as if they were brought in New York? Do any of those cases work their way up through the appeals process to a point where it becomes more of a national issue? Or do these tend to stay more local from what you found?
Well, of course, the most famous of these cases, the one that does make it finally to the U.S. Supreme Court, is Dred Scott.
Right.
Dred Scott was an enslaved person suing for his freedom based on an argument that until the 1850s had been a winning argument, not only in northern courts, but even in southern courts, which was a free soil argument. He said, my master brought me to a free territory. He was actually he'd been with an owner who was an army doctor and brought him to an army base in what was part of the Northwest Territory. So it was free soil. And then he returned to Missouri, which is a slave state. And until the 1850s, even Southern courts would say, okay, if you lived permanently in a free state or territory, you should be free. But when it went to the Missouri Supreme Court, they said times are not as they once were, and basically acknowledged that the political situation had changed so much that the legal result was going to be different too. And they said, you don't, you lose. And it goes to the Supreme Court. And of course, Justice Taney says the very famous words that a black man has no rights that we are bound to respect. And that, I think, really summed up the development that we're talking about in our book, which is this idea that a free person of color by the late 1850s cannot be a citizen of the United States. And that's the real divergence that we're mapping. And you were talking about kind of the legacies today, but I think that link between citizenship and whiteness, that's the thing that's really hard to break, where we still see echoes today in various ways, and that we're still struggling with.
Well, so the ultimate test in the Dred Scott case goes down in failure for Dred Scott. So where were people finding a voice in court then? You mentioned that one argument that some people were able to advance successfully, which didn't do any favors for people of of African descent, black slaves, didn't do them any favors. But if you could argue that you actually weren't black, that you were indigenous, you were Native American, you were something not black, that could be a path to pursue for freedom. I mean, how? First of all, I guess how common was that? I mean, how many people were able to take advantage of that argument successfully?
So for a time, quite a few, and we divide the book, chronologically, and we call that Age of Revolution, going from the time of the Revolution through to about 1830, where you're still seeing, hundreds of people every year being able to make that kind of claim. Not that they all win their cases, but the populations of free people of color in both Virginia and Louisiana double each decade, during that period. It's really a significant growth of these communities. By 1830 or so, I really mark as a turning point. It's a culmination of, that's when Nat Turner's Rebellion is in 1831 in Virginia. The Liberator, the abolitionist newspaper, comes out. There are all of these signs that have slaveholders kind of freaking out. And actually in Virginia, they have a convention in 1831 to 32 where they say, what are we going to do about this? How are we going to react? What are we going to do about slavery? And some people actually say, let's end slavery because they're going to slit our throats in the middle of the night. And we can't do, let's be done with that. And then we'll send them to Africa. And other people say, no, we need to strengthen slavery, but send all the existing free people of color to Africa, remove them. The one thing they agree on is removal of free people of color. And the proposal to end slavery loses by not very many votes, but what they politically agree on is remove free people of color. And so the crackdowns that starts in the 1830s, but by the 1850s is really strong. It shuts off all of these routes to manumission, to freedom suits, and it even provides for re-enslavement of people who stay in the state. And some of the saddest, documents I found in the archives, I'll just mention two. One is a few people try to take advantage of a loophole in these new stringent laws on free people of color. They petition the legislature for a certificate that will say, I am not a Negro.
Wow.
These not a Negro certificates. They would say, I am a free person of color. And sometimes it wouldn't even define what that was, like a free person of color, but not a Negro. And they would get hundreds of white citizens to sign them and say this person is of good character, exempt him from the laws. And then the other, even sadder, kind of document we found are a very few, petition for re-enslavement, where people would say, I don't want to leave my children and my family, so I will choose a new master to stay.
That is just heart-wrenching. So maybe I've overpromised again, Ariel. I don't know, but I'm going to come back to something you said maybe to round out our conversation here, which is you made the point that white male citizenship, which obviously was denied black slaves, until the 13th Amendment and the 14th Amendment, at least on paper, and then for many, many more years, through Reconstruction, through Jim Crow, through to the civil rights era today, in more modern times, and of course was denied to women altogether until 1920. But how does that? I mean, because a good historian is looking for a reason to look at the history that you're looking at, and obviously it's more than just mere curiosity.
Sure.
So what about that do you think continues to be relevant or continues to define or shape how we think about race today in this country?
Sure. I mean, honestly, I wish it were a little less relevant.
Yeah.
So I see a number of echoes and legacies. First, I would say that in the immediate aftermath of the Civil War and going forward, as you say, for decades and even a century, the laws that are put into place to keep African Americans in their place are modeled directly on the laws relating to free people of color. They're not so much the laws of slavery, because those don't apply in the same way, but you already had all of these laws about restricting people's movement and restricting their ability to enter into certain kinds of relationships, like interracial marriage. And those are just copied from before to after the Civil War. And of course, a lot of rural laws that are race neutral but applied racially, like vagrancy laws, things like that criminalize just being poor, and of course, the laws that restricted their freedom of movement were a model for our racially biased immigration laws as well. And when you hear, the president saying, "Send them back," about congresswomen of color, right? It's that same impulse of, a person of color can't really be a citizen, and get them out of here.
Wow.
And it's very, unfortunately, I see these echoes all around, as we see, for example, the Voting Rights Act being cut back, and all of the promise of the 15th Amendment. These are all ways that we're returning to laws that were put into place right after the Civil War. All of these voter suppression laws I can give you like exact counterparts from, 1865, and they're modeled on things from 1835.
Wow.
Yeah.
Wow, Ariel, it's this is so, it's so fascinating to me. And again, as an amateur historian, I would say, or a lover of history, I would say, and of law, and this country, it's so important to know this history. And what an incredible what an incredible amount of digging and storytelling has gone into the book that that you and Alejandro have put together. I really highly recommend it. It's not just good history, but as you've suggested, it's a part of understanding where we are today. To know where we've come from is to better understand where we are today. So thank you for that, and thank you for chatting with me about it on the podcast. I'm really looking forward to this going up so people can share in our conversation. And as I mentioned to you, we'll put a link in the description so that people can order a copy of the book. It is now available. Ariela Gross and Alejandro de la Fuente, co-authors of the new book, Becoming Free, Becoming Black, Race, Freedom, and Law in Cuba, Virginia, and Louisiana. Really fascinating book, and so great to talk with you. Thank you very much.
Thank you.